thank you much for your presence. And thank you very much to Sanita Osipova, Professor Osipova, who invited me to present our research here in Riga, what I do with enormous pleasure. The title of the conference is Civil Law Issue in Europe and Digest of European Tort Law. The idea behind the title is a European research. Is the European research which is going on, which have begun 2003, and since we did not interrupt it. And here you see the first 2 volumes as outcome of the research. At the beginning, there was a dream, the initial dream, a European code, a European civil code. What was the dream? As you know, there are different groups working on a European civil code, and our dream was what would happen the first day after such a European civil code would enter into force. European civil code for the whole European Union and other countries who would like to adopt it. Our dream was what would happen then. How would we behave? What would be our problems? What would be the solutions of the problems? And then we thought on the golden triangle. The golden triangle is an inheritance we have since the codifications, the great codifications of the end of the 18th, then the 19th, and in particular the 20th century. With these codifications, you have a code. We are used to that, but before there were no such codes. We have such codes. We have since academic literature, and we have since court decisions. And this is a golden triangle in the sense that a jurist of our generations, since the codifications, cannot imagine not to have one of these 3 elements. First, you take the code. If you have a problem, you take the code, you look for the solution. If you do not find the solution, you go to academic literature to see whether the problem had been explained, or you go to court decisions to find precedent cases. This is our way to work. Now let's come back to our dream. What would happen the first day after the entry into force of a European civil code? We would have a law, and we would be able to write academic literature. All the academics could sit down and start writing. But what we would not have, it is a court decisions. It would be, in a certain sense, a new code, but no decisions. And then the question is, what would the judge do in this case? If you take national codes, what did the judge do? The judge went back to the legislation before the code and had a look on the jurisdictions. What did the judges say before the national code? But he could do that because there was a national tradition, and the code is a continuation of the national tradition. There's a big difference with the European Civil Code. We do not have one national tradition, we have 27 national traditions, or 29 national traditions, if we add Norway and Switzerland. So the judge, in fact, could not really work. And this was the starting point of our research. We said we have to work on juridical decisions, on court decisions, to put them on the disposition of the judge, who could use it and select the best solutions for the case he would have to decide. So our intention was directed to court decisions. Now, what could we do with these court decisions? We decided that we should make a collection of Supreme Court decisions from all the 27 European countries, the countries of the European Union, plus other countries possibly. And who would be concerned? About 30 legal orders, all in all, from Sweden to Malta and from Portugal to Romania. I made here a map of the countries involved. If we begin with the extreme west, we have Ireland, then we have Great Britain, we have then Scotland also, not Great Britain, England and Scotland. Then we have Portugal, Spain, France, Belgium, Netherlands, Germany, Switzerland, which participates to this research, Italy, of course. In the north, we have Denmark, we have Norway, we have Sweden and Finland. And then if we go down, the Baltic states and Poland. Belarusia is not in Poland. Then we go down Czechia, Slovakia, Slovenia, now Croatia, since it belongs to the European, it's member of the European Union. We have also Romania. We had Bulgaria in the second volume, in this volume here, but this time Bulgaria does not participate. We have, of course, Greece, and we have Malta. So you see 30 legal orders. We decided to work with all these 30 legal orders. The idea being that in these 30 legal orders, we would have an extremely rich scale of cases and an extremely rich scale of argumentations and solutions. This was the idea. If we take the traditional division made in European law, one could say that we have the 4 big circles, which are, beginning by the west, the Anglo-Saxon law. Then on the continent we have the French group, we have the German group, we have the Scandinavian group. So one could say that this could be a kind of mirror, and it reminds me, as interested in history of law, it reminds me the mirror, the Sachsenspiegel, or what had been the same structure in France, La Coutume de Beauvaisis, which is a collection of the court decisions made then in medieval times. So we wanted to do that. As we are tort lawyers, we decided to take the field of tort law and divide it into the main categories. And traditionally, coming up from Roman law, we have 5 concepts in tort law, which are damage, damaging act, causation, unlawfulness, and fault. These are the 5 basic concepts in tort law. Sometimes one is missing. For example, in France, there is no distinction between unlawfulness and fault, but if you look closer to what they do, you find also these 2 elements. To begin with damage, it is naturally the basic requirement. Without damage, you cannot ask compensation or damages. Then the damaging act, I have written here act. It could be an act or an omission, of course. This is an old tradition since Roman law. Omission is considered also as a form of act. One could say damaging behavior. Then causation, it is necessary that there is a link between damage and the damaging act. If there is no link between these 2 elements, of course, no reparation of the damage. Then unlawfulness, this is an old requirement since the 3rd century before our time. In Roman law, in the Lex Aquilia, in the 1st and in the 3rd chapter of the Lex Aquilia, unlawfulness is a requirement for reparation. And then 4th, also very old, from Roman times, a little bit more recent than unlawfulness. It is a requirement coming from Mutius. It is the jurisconsult Paulus, who says in the digest, who gives the definition of fault by Mutius, and Mutius says is on fault a person who has not foreseen what a prudent person would have foreseen. And since this had been said by Mutius, it got a standard element in tort. And as all our legal orders are based from far or from less far on Roman concepts, also not only the continental but also the Anglo-Saxon tort law, we decided that these were the 5 major concepts to analyze. Then, in 2003-2004, we began with the first book. This is the outcome of this book, Essential Cases on Natural Causation. This is the title of this book, which had been published in 2007. What is natural causation? The basic idea of natural causation is, of course, the conditio sine qua non. What is conditio sine qua non? The idea is that is in fact a test made by the judge when he has to decide a case. He asks the question, what would have happened if the tortfeasor had not acted or had not made an omission? Would the damage have occurred or would it not have occurred? If he says the damage would not have occurred, then one considers that it is that the condition, the act was a condition, a conditio sine qua non of the damage. If the answer is no, yes, if the answer is yes, if the judge arrives at the conclusion that if the tortfeasor had not acted, the damage would, despite that, have occurred, then one would say the act was not a conditio sine qua non for the damage. We can take here an example, conditio sine qua non, a short description we give in the digest. I can make an example, a very simple example. I take my book and I throw it through the window, and the window is destroyed. Then the judge would ask, would the window have been destroyed if I had not thrown the book? His answer would be no, and consequently one would have to consider that my throwing of the book, my act, was a conditio sine qua non of the damage. If he arrived at the conclusion that the window would have broken even if I had not thrown my book through the window, then one would consider that conditio sine qua non is not done. My act had not been an essential element of the damage. So this is the basic idea. This conditio sine qua non was the main idea of the first book. What we wanted to know is to what extent do the different legal systems accept this natural causation as a condition. And how did we proceed more precisely? We first had to draft a questionnaire in which we tried to enumerate all the essential situations where conditio sine qua non is relevant. This is the first step. We had to write a questionnaire, and we had to explain precisely what we imagined under the different categories we collected. Here we have, for natural causation, distinguished 11 different categories, and within the category 6 there is 6A, B, C, and 8A and B, what makes that altogether we have 15 categories of conditio sine qua non. You see here the different categories. First, conditio sine qua non in general, what is a general description of conditio sine qua non. Then the second question, damage caused by omission. We wanted to know whether the judge would say an omission can be a conditio sine qua non for a damage, or would he say, as the person has not acted, we do consider that he is not liable. This was the question about omission. Then preventive expenses incurred before the damaging event. This is an extremely interesting category. Imagine that you see that if you don't do anything, tomorrow a house will collapse and destroy your house. In order to protect your belongings, you take precautionary measures. But when you take these precautionary measures, there is no damage yet. So the question is, could you claim damages for the expenses you had for these precautionary measures, even if there had not been any damage? This is an interesting category because it is not evident to give damages without damage. This is the third category we have analyzed. Then damage caused by psychological influence. Normally, in Roman law, there was the concept of corpo corpore datum. What means I have used a physical body and I have caused a damage to a physical body. And this psychological influence says that I can cause a damage without using an object. I can influence someone on a purely psychological level and cause a damage by that. We have an extremely interesting case in Spain where a watchman had to look for a parking in front of a supermarket. Some thieves introduced, who were very young, introduced to steal something in the supermarket. The watchman hurried behind one of these boys. The boy hurries away in high speed, falls and breaks his leg. And the parents of the boy filed an action against the watchman, saying that the watchman has put an enormous psychological pressure on the boy, which resulted in the damage. We have another case, a little bit similar in Germany. It is a watchman in an underground train who controls tickets. And one passenger without ticket hurries away. The watchman hurries behind. The watchman falls in the staircases and gets hurt. And the state files an action against the thief. In both cases, you have a form of psychological influence, because the watchman could decide to hurry behind the boy or behind the passenger, or not to hurry. So, pure psychological influence. And we wanted to know whether this kind of psychological influence could be used by the judge. Then, damage caused by multiple tortfeasors. What happens if several persons cause the damage together? If A, B, and C cause together the damage, A breaks the door, B goes in, breaks the computer, and C plays as the watchman before the door. The watchman before the door has not broken the door, has not broken the computer. Is he liable? So we wanted to know what happens if several persons cause together a damage. Then the category 6, damage caused by less than all possible harmful events. 6A, damage caused by less than all possible harmful events outside the victim's sphere. Here an interesting case, an old case. 3 hunters fire at the same moment into the same direction. And one of the bullets causes a damage. Only one bullet causes a damage. The 2 others were somewhere lost in the nature. Then the question is, what do we do? Because the conditio sine qua non test does not work. We do not know which one I have had. We do not know which one of the bullets, whose bullet has caused the damage. Then the test of the conditio sine qua non does not work, simply because if you ask, would the damage have occurred if A had not fired, you cannot say yes or no. You simply can say maybe. You don't know because you have the 2 other bullets, of which you don't know whether they caused the damage. Then damage caused by less than all possible harmful events outside the victim's sphere. Damage caused by less than all possible harmful events, including events of hazard within the victim's sphere. Here the problem, what happens if maybe the victim have contributed to a damage, possibly has contributed to the damage, or if there are other events which could have involved in that. The classical example for that is you have in a normal population X% of a certain illness. You have a certain town, an industrial town, let's say, where you have 5 times X of the same illness. So you can say that 4 times X damage are caused by the industrial pollution, and 1 times X is natural. The problem is that the patient comes to the doctor, but you don't know whether the patient would have been sick anyway because of circumstances, or whether this individual sickness has been caused by the industrial pollution. What we wanted to know is, what does the judge do if he has this problem? And then 6C, damage caused to less than all victims by harmful event. The category I explained now is 6C. 6B, I have to explain 6C. What I said now within this industrial pollution is 6C. Now for the 6B, including events or hazard within the victim's sphere, can be, for example, the question of natural predispositions of the victim. It might be that the victim has a natural predisposition, or that the damage has been caused by an event outside of the victim. Then the question is, does the judge apportion, or does he say we don't know who is liable for the damage? Then we have 6D, damage caused to less than all victims by 1 or more possibly harmful events. this is another form, further form of these questions of inside and outside elements. Then 7, damage caused by several simultaneous but independent events. What happens if you have, for example, 2 factories causing water pollution, and these 2 water pollutions together cause a damage to a fish pond? Then the question is, would you say as the factory A would have caused the whole damage, it has to repair the whole damage? Or would you say, as the factory B would have caused the whole damage, it has to repair the whole damage? Or would you apportion the damage, saying half-half? This was the question we have had under 7. Then under 8, damage caused by several successive but independent events. It's this classical case. A runs into the car from B, and 1 minute later, C runs into the same car of B. Then the question is, A could say, if I had not run into the car of B, then the car of C would have destroyed it. So I don't need to pay the damage because to repair the damage, because the other one anyway would have caused it. Our question was to know, what would the judge say in this case? Then damage caused by several successive but independent events, we have seen. 9, minimal causation, an extremely interesting case. What happens if the damage you cause is absolutely minimal? The classical example is you have a forest, and beside the forest you have a road. And there are 10,000 vehicles every day going on this road. The damage consists in that the forest is destroyed. Then the question is, what do you do? Because each car individually has caused absolutely minimal damage. Can you go to the car track and say, you have driven on this road, so you have to pay damage? Or would you say, the damage is too small, it will not be repaired? We wanted to know what would be the solution for these cases, and then loss of a chance, the loss of a chance case, which is an extremely disputed case. For example, you have an appointment for discussion with a future employer. You want to get a job. When you are on the way to this appointment, you have an accident, a traffic accident caused by someone else. You cannot go to the appointment. You do not get the job. Then the question is, can you claim damages from the person who has caused the damage, who has caused the accident, saying, I lost the chance to get the job because of you. You prevented me from going to the appointment. This is an extremely discussed category. For example, in France, it is largely accepted. For example, in Switzerland, it's largely refused. And we have the whole picture on this question. Then, haftens ausführlich Kausalität, I would propose now to discuss it further, because it's a typically German question. If someone would like to discuss it, we can do it later. Now, we have these different categories in our questionnaire, and the question is now to know what does the different country reporters have to do, what do they. Our reporter for Latvia is Davis Norgans, together with Yanis Kubilis, and they know that we have, all of us, we have sweat a lot on this work. I personally am sweating now for the Swiss report in the new research, and what each one has to do. each reporter has to select topic cases. If possible, for each category, 3 cases. Maybe 2, maybe 1. And he has to resume each one, to make a resume of each case. And what does it look like? We have to make a resume of the facts, a resume of the decision, and a comment. And the whole should not be longer than 2 pages. I can show you what it looks like. Here, an example from Germany. This is the resume of the facts. Something like 10, between 5 and 10 lines. Then the decision, something like 15 lines. And then a comment, something like between 10 and 15 lines. And naturally with a lot of jurisprudence, other jurisprudences and literature. What should give, as a whole, a good picture of the German, in this case of the German conception in a certain category. So all the reporters make a collection, produce a collection of cases according to the questionnaire. Here I have taken an example. I have shown you this example here. Now the question is, who uses the book? What could we do with this book? And the first interesting use is the one for university teachers. We use it, for example, in our teaching to show to the students the different concepts we have in all around Europe, the different solutions we have, and we discuss with the students the advantages and the disadvantages of these different solutions. What is better if I take this argumentation, what is the disadvantage for this argumentation, and what would be preferable in this argumentation, with counter-argumentation, and so on. This is, for teaching, it is a very useful book. Then lawyers. We had one case where a lawyer from an English lawyer contacted us because he had to plead a case of loss of chance. And he wanted to know what are the argumentations used in favor of loss of a chance, because he had to plead for, not against, for a loss of a chance. He wanted to know what arguments could I use in front of the court. And he filed his texts. It was before before the Australian Supreme Court. And in his texts, he used our book just to show where he took the information from. And the Supreme Court took also our book, had a look on the argumentations pro and contra, and arrived at the decision contra. They decided against loss of a chance. And both used our book and cited our book to explain their point of view. So we have practical use for this book for lawyers and for Supreme Court. For lawyers, just to get to know what argumentations are on the market in a certain sense. And from the Supreme Courts, just to weigh the pro and contra of the different decisions. Of course, Supreme Court could not limit itself to the argumentation found in these books. It is generally the opportunity for Supreme Courts to know the arguments and then to transpose it to the national, to imagine what would it be in the national legal order. And for example, the Swiss Tribunal Fédéral says, apropos the loss of a chance, that it would be basically incompatible with Swiss law. I must confess, and I'm not the only one, I must confess that I do absolutely not understand this argumentation, but it is as things stand at this moment. Then, what are the major results from the digest number 1? We have a normal, an expected and an unexpected answer. The expected answer is that all legal orders use the conditio sine qua non. All of the European legal orders use it. That's what we expected. But what we did not expect is the second answer, that not all legal orders use natural causation explicitly. It means that we have in Europe a certain number of legal orders. It is Greece, Netherlands, Spain, Ireland, Norway, Sweden, Estonia, Lithuania, and the European courts, do not use it explicitly, but implicitly. And this was extremely astonishing. If you think on conditio sine qua non, it seems to be a logical category. There is a causal link, conditio sine qua non, or there is none. And every judge should respect this fundamental concept. This is what we expect. What we have seen is that in these countries, they do not speak about conditio sine qua non. They only speak about what we call adequate causation.
When you compare to European courts, is it like Luxembourg or Strasbourg?
Luxembourg.
Okay.
Yes. But by the way, we take it from everywhere, not from Strasbourg, quasi not, but mainly. But if we can find information from other European courts, we try to integrate, but mainly Luxembourg. About adequate causation, you remember the definition of adequate causation, which goes back to, I think, 1794 in the Prussian Allgemeines Preußisches Landrecht, where it is said that adequacy is what one can foresee according to general human experience and the ordinary course of life. That is the definition used since then. The idea being that the author of the damage should have have made all the reasonable controls about causation, should have predicted damage as Lucius defines it, and if he had not this normally prudent behavior, one would say he was on fault because he has not foreseen. He said, my interpretation may astonish you a little bit, but I consider that natural causation, that adequate causation is not so much a question of causation, rather a question of fault. In fact, if we use this definition we have since the Prussian Code. So what we see is that all of the legal orders use adequate causation, and when they control the adequate causation, they integrate in an intuitive way, I would say, the natural causation. They check both together. They would not go to a control of adequate causation if the natural causation is not immediately given, intuitively given. So this was these were the two major results. We all have, we all think in terms of natural causation, but some of us implicitly and others do it explicitly. Then I would come to the more recent study on damage. This is a book issued in 2011, the same editors and the same group, quasi the same group. One or two authors, country reporters, have been exchanged or have changed because they didn't want to continue. And in this second volume, we wanted to know what is the notion of damage all around Europe. This was the question. What would be considered as a damage in Latvia, in Sweden, in Portugal, in Greece, and so on? So exactly the same idea, basic idea as in the first volume, but we took here another concept, which is damage. Again, we had as legal ID, basic ID, what would be legally relevant damage for the different legal orders. And we distinguished 27 categories of damage, which seems to be a lot. Maybe we will not have a look at all of them, but maybe some interesting categories. We see on 2 and 3 objective value and subjective value. The question is, what would be considered as a damage? Is it something I subjectively consider as a damage, or is it something what objectively can be considered as a damage? More precisely, there's an interesting Roman case on that, which shows this question. There had been a slave killed who was particularly close to the owner of the slave. And the owner claimed that it was his most beloved slave, and that consequently the damages should be very high. And then the question was, is it the subjective conception of the victim which is considered as damage, or is it an objective reference, for example, a market value? And we wanted to know to what extent judges use these objective values, generally accepted value, or are these subjective values. For example, my little beer I had during all my youth, which is destroyed, would one say, I liked it particularly, so the damages must be high, or would someone say, this animal, has no value, no more any value, it is 20, 30, 40, 50 years old, so no damages. This was the question we wanted to ask here. Then loss of working capacity, extremely important in everyday life. What happens if someone loses his working capacity? Temporarily or definitely? Can he go to the judge and say, I lost my working capacity and I want damages for this loss? Then primary and consequential damage. The question you all know, of course, to what extent consequential damage can be claimed for. For example, there are different consequential forms of damage. My car is destroyed, I'm physically hurt, and I cannot work for a certain time. The fact that I cannot work for a certain time is a consequential damage, a close consequential damage. Then we want to know, can the judge give damages for this consequential damage? Another form which we analyzed also in the new questionnaire, another form is the consequential damage, especially in working cases. For example, an enterprise destroys a power line, which belongs to the state, let's say it belongs to the state, and consequently my factory stops. I cannot continue to produce. Then the problem is that my property had not been destroyed. It was the property of the state which has been destroyed. And can I say my consequential damage is a damage, and consequently it has to be repaired. There we have very different solutions. In certain countries, they say consequential damage has to be covered. So me as a factory is entitled to damages. Other countries say, in principle, no, except if certain conditions are given. In Switzerland, we have contradictory solutions. I think you have, for consequential damage, a relatively harsh solution, if I remember well.
Don't remember.
Yes. In my example, I think that the factory would not be entitled to damages. Oh, anyway, we have the book here, we can control it immediately. Then the question, very interesting question, loss of illicit profits on 7. What happens if a thief is hurt in an accident and he goes to the judge and says, I cannot work. I cannot continue for 3 weeks my job of robbery. Typically an illicit profit. We have the same cases also with prostitutes, which is extremely interesting. A prostitute who is who undergoes damage, physical damage generally, and who cannot work for a month or 2 months. Can she claim damages saying, I'm prevented from working? And there the decisions are extremely interesting, and I can give you the solution in Switzerland. In Switzerland, they say, maybe prostitution is not particularly legal, but one thing is certain, prostitutes have to pay taxes, income taxes. Consequently, they are entitled to damages for loss of working. What is, in my sense, absolutely consequent point of view. Then the question of reliance and expectation loss, very important also today. What happens if I buy shares from a company on the basis of a prospectus which is wrong? The prospectus gives me wrong information, I buy shares, and I lose money. Can I then claim for damages because my expectation is deceived? This is an important, economically an extremely important issue. Then other categories, 15, together with frustration, 16 and 17, loss of use. Extremely interesting categories for loss of enjoyment. What happens if my apartment is flooded? One room of my apartment is flooded. I cannot use it for 1 month. Can I claim damages because I could not use my room? Or in the other cases, frustration. I have a car which had been damaged. I put it to the garage for reparation, and during this time, I cannot use it. I'm frustrated in using my car. Or another case, I go to holiday, I take my skis with me, and these skis are lost by the airplane company, and I cannot ski. I'm frustrated of my enjoyment of my holiday enjoyment. Can I claim damages for this kind of loss? And then the 3 extremely interesting categories, 20, 21, 22, wrongful conception. It is the case where a lady goes to the doctor and says, I want to get, I want an operation, I don't want to have any more babies. The doctor makes a mistake and the lady gets again a child, gets pregnant. The question then is to know, can the lady say, I did not want this child, I want damages? This is a really important issue. Then the next case from wrongful birth, where a lady is pregnant and goes to the doctor and says, I would have a prenatal analysis. I would say whether my child will be healthy. The doctor says, everything is okay, the child is born and is invalid, for example. Can then the lady claim damages for the invalidity of the child? And then the most difficult category, wrongful life. Let's suppose that a lady is pregnant, she goes to the doctor, she makes prenatal analysis, the doctor says everything is okay. The child is heavily disadvantaged, is invalid, heavily invalid. Can the child herself or himself claim for damages? Can the child say, I'm invalid, I want damages because the doctor has not seen my invalidity? This is the most difficult case. In the first case, wrongful conception, it is largely now, before it had not been the case, but now it is largely accepted that in case of wrongful conception, when the doctor does not make a correct intervention to prevent new babies, it is largely accepted that in this case the parents have a right to damages, saying that the child itself is never a damage. Everybody would agree on that. During a certain time, judges were opposed to give damages in this case because they said a child cannot be a damage. Now judges in important number of countries say the child is never a damage, but raising a child costs money. And this is the damage. Not the child, but the raising of the child is a damage. So they give very often damages. Then for wrongful birth, it is generally accepted that the parents have a claim. They can claim for damages because they have, for example, more important costs for education. An invalid child costs more for education than a valid child. And the judge would say, you wanted a child and you accepted the cost of education, but you wanted a child which was not invalid. As the education of a handicapped child is more costly, you get the difference in money. The education of a normal child costs 1,000. The education of a handicapped child costs 3,000. You get the difference, what is 2,000. Now for wrongful life, there is an extremely difficult debate because, and we saw that in France in the famous Perruche case, the argumentation of the child would be, I want damages because I have a handicap, but the only alternative would be that the child would not have been born. So the judge would have to choose between a dead child, or not child at all, or a handicapped child, and would have to decide whether this is a damage or not. And this is ethically an extremely question. And in France, there was a case in the decision Perruche. The judges said it is a damage, and then the legislature decided a new law saying that in these cases there are public funds who pay damages to the child. This avoids to the judge to take this extremely difficult decision whether it is better to have a handicapped child than not to leave it to. This is ethically, without any doubt, the most difficult category we have in this volume. Then, environmental damage, extremely important problem. Extremely important because, and extremely difficult also, because environmental damage generally is damage to res nullius, to a thing which belongs to nobody. Air belongs to nobody. Water belongs to a large extent to nobody. The beach, very often, belongs to nobody, or quasi to nobody. And there are really different solutions. In France, for example, they have a very far-reaching protection through for environmental damage. We have an extremely interesting case in Switzerland. The case was this. A rare bird, Gipelbach, which is a large animal, living in the mountains. And there is a company in the Netherlands who breeds these animals. It is a non-lucrative enterprise, breeding these animals and putting them back to the wild. And they brought one of these birds to the Swiss Alps. And then came a hunter and killed it. Then was the question, is someone entitled to damages? And the breeding company had claimed for damages. And the answer of the judges was the animal had to be put back to nature. It was a case of abandoning. They abandoned their property, which means that the animal had no more property, no more owner. Consequently, no damages. They said in the same decision that if the company had decided to replace the animal by another one, then they could have claimed for damages. But in back of this decision, no damage. And then loss of a chance, mere exposure to a danger, 25, category 25. The question is, can you consider as a damage the simple fact that you are exposed to a danger? I can take an example. Let's suppose that your neighbor stores explosives on his ground. And if these explosives blow up, you will have damage. But up to date, the explosives have not blown up. Can you file an action for damages simply because you are under danger? And there are extremely interesting decisions. One is a medical decision where a doctor should have operated the leg of someone, but instead of operating the leg, they put off a kidney. What means that the patient had not 2 kidneys, but only 1 kidney. And this person failed a claim, saying that it is more dangerous to live with 1 kidney than to live with 2 kidneys. And he got damages. So this shows what it means for us to be under danger. It depends on the exposure to danger, but it can give, in certain cases, give rise to damages. And then we have loss of a chance, of course. Is the simple loss of this chance to get a job, is this considered as a damage? And as I said to you, in France, it is considered as a damage in numerous other countries. It is not. So what we wanted with these 27 categories is to know exactly what does a legal order consider as a damage. Now, we have seen different examples. Now let's see the major results. We can say, I take just some interesting points, that all countries submitted cases of illicit profit. We have discussed this case of a prostitute, for example, who gets hurt, or a robber. All the countries have submitted cases of illicit profits, but most countries refuse to repair this type of damage, but several nuance this of socially and individually harsh solution. For example, Netherlands, Sweden and Germany. There are others who try to find a socially more acceptable solution to these cases of illicit profits and environmental damage. Here also most jurisdictions are confronted with this kind of damage. Two, most jurisdictions see the state as the most suitable claimant. This is one of the most of the important questions. Who can fail a claim in case of environmental damage? And most of the states of the countries say it is on the state. Sometimes there are also private associations who may. And then in France, interest groups are considered to have immaterial rights which are harmed by damage on the environment. So these are particular outcomes of the research. Now, how can you use that? We have decided to present the case, the book, in the following way. You have category by category the same countries. We have, as a first country, first we have a historical report. Then number 2 Germany, number 3 Austria, number 4 Switzerland, number 5 Greece, number 19 Estonia, number 20 Latvia, 21 Lithuania, and so on. So each country gets, in a certain sense, a number. And this numeration is respected through all the categories. So you have two ways to look at the book. Or you're interested in a problem, for example, category 7, and you read all the cases on the category 7 according to this list. Or you say, I am interested in the jurisdiction of a country. Then you go from category to category. You take, in your case, for Latvia, number 20, you go in the first category and you take Latvia, country 20. Second category, you go to Latvia. Third category, you go to Latvia. So you can all read the book in a vertical way by problems, or in a horizontal way by countries, which allows you or to know exactly about your country or specific country, what are the solutions, or to work by problems. What probably would be the way lawyers do it, or Supreme Courts do it. They will take, of course, categories, and then they will analyze the different jurisdictions inside the same category of damage. This is the way we have conceived it, and we hope, of course, that other countries or other groups will continue these analyses. In the overview, we ask to other institutions to take other fields of civil law, for example, contract law, or for example, family law, or for example, inheritance law, law of succession, and to make the same analysis in these fields. What would allow us to have a whole range of analysis of the whole civil I have seen 1 year ago that ELI, the European Law Institute, which had been founded 5 years ago maybe, has now such a program. They would like to cover the whole civil code with these kind of decisions, probably a little bit on the type of work we are doing here. Now I have spoken a lot. Maybe you have some questions, and we could discuss the first 2 volumes, and after I will present the 3rd volume, which is on which we are working on now. But maybe you have already questions for these 2 first volumes.
Yeah, just a short question. Wasn't it difficult for some countries, I imagine, to distinguish in such a detailed way that you asked questions? For example, this loss of use or loss of profit. So wasn't it difficult to make this distinction in such tiny detail?
It depends on the countries. Small countries have more difficulties than big countries because the number of cases is not the same. A typical case for very nuanced jurisprudence, the court decisions, is Germany. They have an infinity of categories and subcategories. Austrians also, France also. Spain has a very rich palette of decisions. Smaller countries, less. I think the C's is one of the important criteria. And then there is another criteria we discovered later on. There is another criteria, which is, in a certain sense, the way to behave towards negotiation. I can take an example. The question is, do parties rather file claims or do they rather negotiate? And I can take one example, the question of loss, wrongful birth, wrongful life, and wrongful consumption. Up to 2010, we did not have one single case in Switzerland. And we never found out why. And then, incidentally, we discussed with the insurers, and they say, we negotiate. We don't want to have this kind of claims. And they negotiated all the cases except one. So it depends a little bit whether, what is the mentality in a country? Do you negotiate or do you want a court decision? But in any cases, it was always difficult to find sufficient decisions, especially for small countries, like yours or mine or others.
I would like to ask you. First of all, I would like to ask about future, not with this 3rd volume, but about principles of European yes. The groups which are working with contract law have decided that to get to the code of Europe is impossible. And they are now looking for some draft common frame of reference. Later, surprising was that it can be regulation as proposal and so on. You are closer to the Brussels. Can you say maybe what steps are taken to push these principles to some maybe official result? It's one question. And second, as you are the editor and reviewer of such rich collection of various cases. Maybe you told us about some differences, but it are not sensation, it's not surprising. But maybe you have noticed some surprising solutions in some country on these cases.
On the ongoing research, you mean, or on the old
No,
ones?
eine Laie.
Yes. I begin with the second question. What were there surprises? I would say that in the first one, the real surprise is that conditio sine qua non is not really elaborated in all the countries on the theoretical level. If you look at the distinction between conditio sine qua non and adequate causation, you see the definition of adequate causation for the first time in 1794 in the Prussian Code. And if you look at conditio sine qua non, it has been elaborated in the 19th century. In the 19th century, second half in particular. There you find, in the legal literature, you find the discussion of what is conditio sine qua non. So one could say that since the 19th century we have a legal culture distinguishing between conditio sine qua non and adequate causation. What is surprising is that this discussion, this old discussion in a certain sense, had not been taken, integrated in all the countries. This was, for me, really a surprise. And another surprise, you can find it crazy, but another surprise was for me that with the 27 categories we have in damage, there were not much more categories proposed by the different reporters. The last category in each questionnaire is, do you have other categories? And there have been proposed very, very few further categories. What means that we have, despite your question, I would say a limited number of categories of damage. It could have been more, seeing that thousands, hundreds of thousands of cases have been decided. Only 27 categories, it's not much. I would have expected more. I don't know whether you share my point of view.
For me, when I was looking at the list, it was just surprising that I was thinking about whether I could find in my memory different types of cases that could be added or could be used as illustration for your list. So that was just a question, because I could not imagine how you distinguish loss of use from loss of enjoyment as you described it. In that sense, that it was not easy to understand the distinction.
The distinction would be, you have cases like that. The loss of use would be, you lose your instrument for working. Yeah. Loss of enjoyment would be, your holiday is spoiled. This would be the main distinction. These are two different things. Or, for example, you have a car for commodity. You even don't use it for your job, but you just have a car. It is not a special pleasure. It is not necessary for your job, but you want to have a car or a bike to go do some biking from time to time. You are frustrated in its use. Maybe you can claim damages. And then your first question, what about projects? On the table we have now, from 2005, the Principles of European Tort Law, which have been published by the European Group on Tort Law. These are, it is the correspondent to what the Commission Lando has made as the Lando Principles. Principles of European Compact Law. This is the first important text which has been published, and then the second is the one you mentioned, the Draft Common Frame of Reference in 2010, where is integrated also a part of in total. So we have two proposals on the table. We have on the national level we have an interesting scene. There are a lot of revisions going on, and one single revision up to now has succeeded. It is the Turkish revision, which entered into force I think in June 2013. So they have released their tort law. They have now a new tort. Then we have revisions going on in Austria. I don't know where they are. A revision in Switzerland, which is locked. A revision in France, which is prolific. All the time you get new texts, new proposals. Not sure what will happen. So we have an interesting landscape. Different proposals which we could take, and beside that we are revising the Principles of European Tort Law. I told you that they were published in 2005, and we restarted to work on it in 2011 maybe, and we would like to complete it, and we would like to add different fields. Add as one of the possible fields to add public authorities liability. This could be one thing. Product liability we are working on. We have worked on questions of borderlines between tort and contract. Cases where you could file in tort or where you could file in contract, or neither of them. And then today I got the newsletter from ELI, from the European Law Institute. Probably have gotten it also on your internet. And they made an extremely interesting claim. They claim for new projects, and they would, as far as I understand it, they would have different groups working on different topics. And one of the topics they propose now, it is tort law. And the groups for tort law are now under construction. So if someone of you wants to continue, then it would be useful to be member of ELI, what is easy to be, and to take contact with people working in these topics. It could be interesting, because ELI, this European Law Institute, develops like an atomic mushroom, like an atomic. It's very fast, and suddenly within some months, within a few years, you have this enormous construction with extremely competent people, and this would be a nice opportunity to participate. This is what I see on the horizon at this moment. In Latvia, tort law is not under revision. You're satisfied with you have good experiences with the code you have?
No, there are some proposals, but very long key to get to the parliament. More actual things are before.
Yes.
The jurisprudence can develop on its own in parallel of any legislative changes. That's the best of it.
Yes, this is one of the possible options for national law. For European law, we have to find another solution. We have to draft. I think that certainly you know the drafts of Principles of European Tort Law and the draft common frame of reference. Personally, I'm not satisfied with neither of them. I think neither of them is up to what we need, by far. I'm working in the group of European Tort Law, so I'm personally involved, but I think we have not reached the level we need. And this will be a discussion for tomorrow. I think it is not easy to put on the one hat 27 legal orders. This is extremely difficult. Yes?
I have just a general question. Do you think, it's really like to continue the professor's question, if it's really possible to live this dream for a common European civil code about the tort law? Because there are so many countries, and the biggest countries like England and Germany, they are strict to their national laws, and they will never accept something that they don't have in their jurisdiction. So how do you think is it possible in the near future, or is just it will stay like a dream, and will stay like only to the scholars to learn how it's in different countries?
If you permit, I would give you a twofold answer. The first thing would be what is perfectly subjective. I would say by doing that, we have a lot of fun. This is very important. Fun, science without fun is not science. And we have a lot of fun by doing that. We are sweating. It is hard work, that's true, but we have a lot of fun. It is intellectually extremely stimulating to dream this dream. This would be my first answer. And then I would take a second answer, which is much more realistic. Europe is difficult. It is difficult to say where Europe goes today. Europe can take different ways. It can also take the way, among others, the way of a European civil code. It is not impossible. It is one of the possibilities. And if Europe takes the way of European civil code, then we have to be very fast. Then we will not have a lot of time to do that work. And what we are doing now is, in a certain sense, to build the basis, to build up our own competence, to draft within reasonable time a European civil code for the case that politics would decide in this direction. I think there is a kind of responsibility. We have a kind of responsibility in this question. We have to be ready to propose a good solution, but with the possibility that nobody will ask you never to draft a European civil code. But we have to be ready, and that's the reason why we should do it. It is a kind of fundamental research what we are doing. And we will see what will be the outcome. But you seem rather pessimistic.
Yes, I am a little bit, because this common European civil law is also stopped because of the biggest countries do not want to accept this kind of idea, even if it was a regulation that is not binding. So I'm really pessimistic about this binding effect that we can get.
But in my experience, when I discussed with the most conservative of my colleagues, when I discussed the Lando principles, the principles of European contract law, even the most conservative ones said that they would not have any objection against none of the articles in these principles. So I think that we have already reached a level of minimal consensus. And the principles of European contract law are not a weak consensus. The principles of European tort law and the draft common frame of reference, apropos tort law, have a weak consensus. It means They just try to join a point where everybody agrees. The principles of European contract law had been built on another basis. They said we want strong decisions. You see that in the hardship, for example. You see that in the mailbox rule also. They have taken strong decisions, and I think the acceptance, the general acceptance, is not too bad. So I'm not so pessimistic. I propose maybe a break of a quarter of an hour, if you agree.
10 minutes would be 15.
10 minutes. As you want. Or 5 minutes if you want. Or none. Please have a look at that. You will go there.
Audience is little because they can see it in our faculty home.
Okay.
This is my colleague from University at Court, constitutional judge and Professor Kaspars Pavlovs. We're getting to know now in this point.
Ah, wonderful. Show it. Thank you very much.
Kaspars is polyglot too. English, French, German, Russian, Latvian. From our company. Do you understand a little bit French?
No,
I know.
Almost no.
But a lot of other languages.
German,
Fluently,
English.
like native speaker German.
Sie sind Deutschsprachig.
Ja, ich spreche auch Deutsch.
Ja.
Magisterstufe und Doktorstufe ist in Münster.
Das ist meine erste Fremdsprache in der Schule.
Ja. Dann kennen Sie, wenn Sie in Münster waren, dann kennen Sie vielleicht den Kupisch.
Ich habe den Namen gehört.
Im römischen Recht hatten Sie
Kupisch. Ja. Ich habe den Namen gehört, aber ich kenne ihn nicht. Schermeier.
Das war Ihr römischer Rechtsprofessor.
Ja, habe ich auch gehört.
Ja.
Aber so persönlich erlebt.
Ja. Nein, ich kenne Sie, weil Sie Romanisten sind.
Ich kenne Rechtsgeschichtler, Hartenhauer und Ostmann und
Ja.
Schlüter war nicht mein Doktorvater, aber Patron, wie kann man das sagen, ein Stipendium zu bekommen. Wilfried Schlüter, Ehrrecht, Zivilrechtler.
Und Hattenhauer, waren Sie denn Vater oder denn Sohn?
Holzhauer.
Ah, Holzhauer.
Holzhauer. In Münster ist Holzhauer jetzt emeritiert.
Ja, aber er war ja in Kiel vorher, Holzhauer.
Ja.
Und da ist er Vater und Sohn.
Ja.
Und Sie kennen den Vater wahrscheinlich.
Ja, alle.
Ja, der Holzhauer, der ist interessant. Der weiß viel.
In Münster ist eine wunderschöne Rechtsbibliothek. Da ist Koschakers Rechtsbibliothek. Diese alle alte sumerische Quellen übersetzt nach Deutsch und akkadische Quellen und Reichtum. Für Rechtshistoriker, da ist Reichtum. Und kann man langsam und ruhig arbeiten.
Ja. Und Sie unterrichten?
Ich unterrichte allgemeine Teile des Zivilrechts und Handelsrecht.
Ja.
Aber mein Hauptjob ist Verfassungsgericht und so habe ich ein bisschen zum Beispiel auch den Kontakt zur Uni Münster verloren.
Wir haben weniger Zeit für Wissenschaft.
Ja, den ganzen Tag im Verfassungsgericht verbringen. Aber Sie waren bei uns doch.
Ja.
Ja, das ist nicht weit von der Uni.
Ja. Ich hatte das Privileg mit dem Präsidenten.
Ja.
Mit Alex, glaube ich.
Ja. Das ist auch interessant.
Wir haben 2 Zivilisten, wir sind 7, 2 sind Zivilisten, 2 sind Internationalrechtler, ich bin Rechtssoziologe und Strafrechtler. Bevor war 3 Strafrechtler.
Vorher hatten wir 3 Strafrechtler.
Ja, das
aber so einen echten Staatsrechtler haben wir nur einen.
Kusinsch.
Ja, Verfassungsrecht.
Aber ohne Doktorstufe. Er ist Praktiker.
Ja, aber das ist da nicht unbedingt
in unserem Gericht.
Ja. Das kann auch nützlich sein. Ein guter Praktiker kann nützlich sein.
Er 20 Jahre lang arbeitete im Parlament.
Ja.
Er leitete diese
die Rechtsabteilung des Parlaments. In unserem Parlament haben wir eine Rechtsabteilung.
Ja.
20 Jahre er arbeitete da.
Ja,
war Leiter.
Dann kennt er wahrscheinlich die Verfassungsprobleme ziemlich genau.
Ja, und er erinnert mit jedem Gesetz, wie das passierte, was war für Diskussionen.
Wir haben einen interessanten Fall, der war Anwalt und er wurde dann Bundesrichter und einer der besten Bundesrichter, die wir überhaupt hier hatten, den Hans-Peter Walter. Und bevor er Emeritus am Bundesgericht wurde er an die Universität gerufen und man gab ihm den Honoris Causa, weil er nicht einmal eine Doktorarbeit hatte. Man gab ihm den Honoris Causa und so konnte man aus ihm einen Professor machen. Und ein ganz ausgezeichneter, auch Professor, sehr gute pädagogische Fähigkeiten.
Aber ohne Doktorarbeit. Und manche haben Doktorarbeit. Und nur Doktorarbeit.
Ja, genau. Ja.
Gibt es in der Schweiz auch Habilitation?
Wir haben 2 Systeme. Wir haben das in der deutschen Schweiz das deutsche System und in der französischen Schweiz das französische System. Das deutsche System hat die Habilitation und wir haben von den Franzosen la thèse d'état geerbt sozusagen. Das heißt, zuerst haben wir ein DES, Diplom d'études supérieures. Das ist eine kleine Doktorarbeit. Und dann macht man die Doktorarbeit, das ist eine kleine Habilitation.
Bei uns in sowjetischer Zeit war wie in Deutschland zweistufig.
Ja.
Am Anfang Kandidat, nachdem Doktor. Und wenn wir haben unsere Systeme gemacht, wir dachten, wir haben 5 Jahre für Qualifikation, dann eine akademische Magisterstufe und diese Magisterarbeit will wie diese deutsche erste Doktorarbeit und nachdem kommt große Doktorarbeit. Und mit dem Bologna-System, das alles, wir haben verloren und jetzt wir haben nur keine akademische Magister mehr, professionelles Magister nach 5 Jahren. Und die sind nicht immer so fertig für Doktorarbeiten nach den 5 Jahren Grundstudium.
Ja, natürlich. Das ist eine schwierige Frage.
Ja, aber diese Kommunikation, das war in Lettland nicht mehr haltbar. Nicht mehr haltbar, weil in einigen Zweigen der Wissenschaft gibt es zu viele alte Wissenschaftler, zu wenige junge.
Ja.
Ich würde nicht sagen zu viele alte Wissenschaftler,
nicht genug.
deren Zahl auch ist auch nicht sehr groß, aber zu
Nicht
wenige
genug.
junge.
Ja.
Und wir haben verloren diese Generation zwischen 50 und 65, weil die musste seine Doktorarbeiten fertig machen die Ende 80er Jahre. Ja, und dann diese Perestroika und für Juristen, die waren verloren Arbeit. Diese sowjetische Recht, sie haben Anfang im sowjetischen Recht und sie konnten nicht das enden mit diesem Thema in unabhängigen Lettland. Darum wir haben verloren ganze Generation.
Ja, das ist ein Riesenproblem. Aber dennoch, wenn man die Tiefe dieser Veränderungen sich ansieht und wenn man sieht, wie diese Länder, wie es in diesen Ländern jetzt ist, muss man sagen, haben sie eine wunderbare Arbeit geleistet. Das ist wirklich bewundernd. Es gab wenige Opfer, also militärisch gesehen wenige Opfer.
Ja,
und vor allen Dingen die Zivilgesellschaft, die wurde sehr schnell auf die Beine gestellt. Das ist
Bei uns, das war möglich, weil meine Großmutter war beziehen in diese Zwischenkriegszeit und war lebende Erinnerungen. Das war die Möglichkeit für uns und das war nicht in Russland, weil Russland, diese sowjetische Zeit ist seit Anfang 20. Jahrhundert. Das ist eine Generation vor. Ja.
Also ein russischer Dissident, der hatte ganz treffend die Sowjetunion als Antizivilisation bezeichnet.
War das Zinoviev?
Zinoviev, ja.
Hat das,
ja, Zinoviev.
Er hat ja gesagt, der Homo sovieticus ist ein irreversibles Phänomen.
Ja.
Was wahrscheinlich falsch ist. Aber er hat gesagt, es sei eine Antizivilisation.
Ja. Und das war auch sehr, sehr treffend, weil es war immer so ein Kriegszustand des Staates gegen die eigenen Bürger. Das hat auch ein Professor unserer Universität, er ist Leiter des Studiengangs für Asien-Studien.
Ja.
Und er sagte einmal, dass das Leben in einem sozialistischen Staat, das ist so ein Leben wie im Krieg. Das war so insgesamt. Mit aller Unterdrückung, Knappheit und
An der Ende war ganz schlimm. Ende 80er Jahre war nicht genug Lebensmittel, nicht genug Schnaps, nicht genug Seife, nicht genug Waschmittel. Wir haben wie in Kriegszeit Kartensystem.
ja,
Ich weiß das noch, als wir heirateten, meine Frau ist Toni, als wir heirateten, begann meine Schwiegermutter 6 Monate vorher die Fleischkarten zu machen.
Die Karten, ja. Fleischkarten und Alkoholkarten und Seifekarten und
Ach, Sie hatten sogar
Seife und Waschmittel.
Nein,
Diese Waschpulver.
Da gab es nur für Fleisch. Im Polen gab es Fleisch. Also ich kann mich nicht an
Bei uns war ganz schlimm.
Ja.
Ja, können wahrscheinlich
Schön. Machen wir weiter.
Machen wir.
which is on misconduct and which should issue in 2017. This is our dream, another dream we have. But, we are working hard to attain our aim. It is not anymore the same additional team. Here was the team Helmut Kotzio, Bernhard Koch, Reinhard Zimmermann, and myself. And now I'm working with 3 other young colleagues. One colleague from Austria, Ernst Kahner, who is in Vienna. Another colleague who had been in Vienna and is now in Bristol, Ken Oliphant. And an Italian colleague who is Alessandro Scarso from Milan. So we have changed the team, but the idea, the basic idea is still exactly the same. Now, misconduct is a crazy title, and that's what Calvis Torgans told me. Misconduct, how could you choose this title? Our problem was the following. We wanted to tackle something like unlawfulness. Unlawfulness in the sense of injuria, in the Roman sense of injuria, a break of the law, or sometimes people call it also wrongfulness. And we could not tackle unlawfulness because the French system has no unlawfulness. If you take the article 1382 of the French Civil Code, they speak only about fraud, but not unlawfulness. And this despite the fact that in the work of the Parliament in 1804, they spoke about unlawfulness. The presenters of the project of the Civil Code spoke about unlawfulness. Baril, for example, was an excellent jurist. He said we need unlawfulness. And then when we saw, when they wrote the article, there was no unlawfulness. And what we know today is that unlawfulness has a clandestine, in a certain sense, a clandestine existence. It is covered by fraud. So we could not tackle unlawfulness, but because France, Spain, Portugal, Belgium, and so on, do not, all those who are under the influence of French law do not have unlawfulness. On the other hand, we could not tackle simply fraud, because for our systems, for your system, you cannot tackle fraud if you have not tackled unlawfulness. Because fraud and unlawfulness are like the left and the right hand. They go together. So we had to find a general term joining unlawfulness and fraud. And this is for this reason that we took misconduct. Misconduct in the sense that there something has gone wrong. It can be wrong. It can be wrong in the sense of break of the law, or in the sense of fraud. This is the reason why we took misconduct as a general term. Personally, I'm not especially happy about the term, because conduct, as Calvis Torgans said 5 minutes before, misconduct suggests an action. Conduct is, we have to take conduct in the sense of behavior, misbehavior. This was the first term we had, misbehavior. And then our English colleague Ken Oliphant said, in English it sounds odd, and we accepted misconduct. I did not behave in a correct way. So, under misconduct we have both. We have unlawfulness and fraud. And again, we made a questionnaire. And in this questionnaire, the first point was to distinguish between unlawfulness and fraud. This was the first question we asked. It is on the general overview. It's a general description in 2 or 3 pages, general description of the country system. And then on the 2 forms of misconduct, where we wanted to know what notions we have in each country. It's to say, do you have unlawfulness? Then say it. Do you have fault? Then say it. Or if you have only fault, then say it. There is no country who has only unlawfulness. So it is, in a certain sense, the summa divisio within each report. We know you have unlawfulness and fault, or you have only fault. The reason why we have this first category. And then on the 3, the criteria for assessment. This originally goes back to Roman law. If you take Roman argumentation, you had to prove unlawfulness. The judge could give you damages only if you had proved the unlawfulness. And the Romans, in order to prove unlawfulness, since Mutius, the fragment I described you in the first hour, since Mutius, if you wanted to get a judgment on unlawfulness, you had to prove fault. Once you had proved fault, the judge would say your act was unlawful. And how did you prove fault? Then you have a catalogue of argumentations. What we have explicitly in the Roman sources, it is, for example, incompetence, it is weakness, physical weakness, it is inexperience, and so on. So, if I wanted to get a judgment on lawfulness, I had to prove through criteria like physical weakness or inexperience that the person was at fault. What was an indication that it behaved in an unlawful way. Now, this unique chain of argumentation had been broken with the codifications, because your codification, as well as ours, not the French, but ours, make a distinction between unlawfulness and fault. You have to prove unlawfulness, and then a second proof, an independent proof, you have to prove fault. And if you look exactly at the argumentation you find on the fault, you see that it is subdivided. Very often, instead of fault, judges, sometimes also legislators, use terms like inexperience, like negligence. Negligence and fault are extremely close. In certain countries even have the same meaning. And you have other argumentations. And we wanted to know, what kind of argumentation do you have still today? We know that from Roman times we have this multi-argumentation, and we wanted to know what are these criteria of assessment. What could you use as an argument for fault? Negligence, inexperience, carelessness, and so on. This is the category 3. And then the criteria and their interplay. We wanted to know, how did these different categories work together? What was exactly the mechanism of working together of these categories? The different criteria, the nature and value of the protected interest involved. What kind of interest could you say had been violated? What is the interest you value? For example, physical integrity, bodily integrity. For example, material integrity. For example, economical interests, and so on. How do these different elements work together? And then the dangerousness of the activity in question. Could someone say, your activity was particularly dangerous and you had to take measures to avoid damage? This is a very important topic in industrial life, in modern life. For example, if I have a dangerous machine, could someone say, you have a dangerous machine, and because you have a dangerous machine, damage has been caused, and the reproach is that you had not taken the protective measures. Typically in the industry, or also at home, you remember maybe up to the 70s, there had been in laundries these machines turning around, unprotected. And there have been plenty of incidents. And then the court said to the owner of the factory, you had such machines. It would have been extremely simple to put a cover on it and no damage would have occurred. So the dangerousness of the activity is an argument for unlawfulness and for fault in the first step. And then the foreseeability of the damage. Was it for? Could one say you should have foreseen? You could have foreseen that this would happen. Could one say you were at fault because you have not foreseen what a person, a normally diligent person, would have foreseen? This was the question we asked here. Or a relationship of a relationship of proximity or special reliance between those involved. The relationship of proximity is typically the relationship between a teacher and a child. If something happens to a child, the parents of the child could have as an argumentation, the child had a particular relationship to the teacher, relied on the teacher, and the teacher did not do what he should have done in this situation. And this could be used as an argument for the fault of the teacher. Or the relationship of a special reliance between those involved. Typically, you go, you have confidence in an expert. You take his analysis, which he published in the newspapers. You have no contractual relationship. You rely on him, and his recommendations were wrong, and you lose money, for example. Could you say I had a special relationship to I had a special reliance on this expert, and I have been deceived in it. We have here an extremely interesting case in Switzerland, which is the following. Swissair, when it existed still, had a daughter company, and this daughter company made public relations with a letter. It was an economically independent daughter, and they have the logo of Swissair at the bottom of their letters. And they have sold apartments, parts of apartments, to a victim, and went bankrupt, and the victim never recovered the money he had invested. And then he filed a claim against Swissair, saying that Swissair had tolerated, because they knew that the daughter used the logo of Swissair, that they had tolerated the use of the logo by the daughter, and that this use of the logo had created a special reliance from the victim to Swissair. And in fact, the victim got damages. What is extremely interesting. No contractual relationship, absolutely no direct relationship, but simply a reliance, particular reliance, what we call a relation of proximity, which justifies damages from Swissair. Then the availability and the cost of precautionary and alternative methods. Typically, the question is to know how difficult would it be to avoid a danger? Would it be economically costly, or would it be affordable? In my example of the laundry, the judges said, extremely simple, you put a cover on it, it costs $10 maybe, and your employees are safe. Typically, these kind of argumentations we would have here. Then the relevance of statutory and of non-statutory norms, 4 and 5. The question was here to what extent a judge for non-statutory norms could use, for example, medical standards dictated by medical science. The question, for example, if something goes wrong in an operation, in a medical operation, could the judge use the standard dictated by the medical societies to establish whether the doctor has made a fault or whether the doctor has acted faithfully. Then special skills or expertise, the question whether the level of your formation could be taken into account. Would you consider as a fault something according to the professional standard of someone? If someone, for example, is an average doctor, would you apply an average standard? And if someone is a hyper expert in surgery, would you apply a standard of hyper expert in surgery? So what is the influence of your professional skills on the level of fault required? This was the question we wanted to have here. And then experience or lack of skill, the opposite. If someone has really absolutely no experience in a professional field, would the standard of fault be lowered? And then physical disability. I'm physically disabled. Would it have an influence on the fault level? And mental disability, of course, the same question. What about drugs and alcohol? If I cause a damage when I'm under influence of alcohol, what would the judge do? Would he say, okay, you were drunk, you did not understand what you did, so you do not have to pay damages? Or would he say, it is your fault to have been drunk, consequently, you have nevertheless to pay damages? This is a question of fault, because if the person does not understand what she does, or what he does, then in principle he is not considered as faulty. He has not the competence to be faulty. In this case, in the alcohol case, one would say, your fault was not to have done what you have done when you were drunk, but your fault was to get drunk to a point that you could not anymore decide on what you should do. Other transient factors with various possibilities. Then the degrees of misconduct is an old question which had already been raised by Alpian, who distinguishes between culpa lata levis e levissima. The question is to know whether the degree of fault has an importance in the case, and whether the legal order makes the distinction between these different degrees. In fact, there are two questions in this case, in this category. The first is, do your courts distinguish between different levels of fault? And the second question is, if you make this distinction, do you adapt the damages to the degree of fault? I can make an example. I make a very small fault and I cause a damage. Would the judge say, as your fault is very small, you have to pay small damages? Or would he say, your fault is very small, but despite that you have to pay full damages? This was the question. And here we have very different solutions, as it seems. Then self-defense and other grounds of justification. What happens if you have caused damage within self-defense? And there is an extremely interesting theoretical question underlying. If I cause a damage in self-defense, normally legal orders say you do not have to repair the damage. This is the standard answer. The theoretically interesting question is to know whether, but practically of absolutely no importance, the theoretical question is whether if you have caused damage during self-defense, this damage would be considered as unlawful or as lawful. Because you can say you have caused damage during self-defense and it is lawful, consequently, you do not have to pay damages. Or you could say the damage was unlawful, but despite that, you have, as you have a justification, you do not have to pay damages. The outcome, the practical outcome is always the same, but the theoretical structure beneath is not the same. In one case, we would say the damage is unlawful, and in the other case, we would say the damage was not unlawful. Personally, I prefer to say the damage was unlawful for theoretical questions. For theoretical reasons, I would say the damage was unlawful. But as you have as it was self-defense, you do not pay damages. This solution would have my preference. And then a really funny 15, self-defense against non-misconduct. This is a funny category, and you can take the following example. You are lying in your bed at hospital, and you need medical treatment. Then the doctor comes and makes you an injection. And at the last moment you see that the doctor takes the wrong product, and that the product he uses will be lethal. You see it at the last moment and you box him. You damage him. The question is then to know whether you could say it is true that you have caused damage, but it was a damage in self-defense, but it was a self-defense against a lawful act. This is the combination we have here. It is a funny question, but of some limited practical importance. But these cases do, in fact, exist. You do something against a lawful act, and you cause damage by doing that. There was an interesting case. I think it was from Spain, but I'm not sure. Someone is in his house during the night, and he has the impression that there are robbers. He calls the police. Police comes. They don't have uniform. They are in civil clothes. They come close to the house, and the man inside the house believes that these are the robbers and shoots them. It's typically this case. And then, of course, the police, the police claims damages for the damage undergone. And of course, the question is to know whether he can say, but I believe that these were robbers. I could not know that these were policemen. So these cases do exist, but they are not in the most numerous ones. And then finally, additional questions where the different persons can, the different reporters can add points which are not in the questionnaire. Our forms here again an example. Forms of misconduct. What forms? That's a question of the explanation we give. What forms of misconduct, wrongfulness, fault, others are recognized in a legal system, and how, in outline, can they be established? If wrongfulness is a prerequisite of tortious law, liability, does it focus on the harmful result as such, a Volksrecht, or on the human conduct that caused that result, Verhaltensrecht? And then we give systematically examples. The second example, I can cite this, which is skier A, who is skiing too fast, collides with skier B, who is standing looking downhill in an easily visible position at the edge of a broad slope. Both skiers are injured. What rights of action, if any, do they have against each other in the law of tort? You have an example of what we are sticking on to. We give examples, and we would like that the reporters take cases which correspond to our general description or to our examples in the questionnaire. Merci de votre attention. Thank you very much for your attention, and I'm open to all kind of questions, of course, on tort law or something in the field of civil law.
It was quite interesting. I saw that in the collections you have even judgments from 1958 from Poland.
Yes.
So I would think that usually the states would choose fresh judgments, but instead they are choosing judgment which is like 60 years old. I would think that it was even different legal situation was solid epochs.
This was a serious question we discussed among us, as a rule, we said, in principle, we want the most recent topic cases. This is the first principle. Then the second principle is that if there are contradictions, you also can take contradictory decisions, which illustrate one option and an opposite option. This is the second rule. And then a third rule we have, which is taken from England, from Scotland and Ireland. You take a leading case, and in the new collection we will have cases from the beginning of the 20th century, which are still the leading cases. And I made exactly this remark to Ken Oliphant when I said this seems to be a rather old case. Is not? Don't you have something more recent? And then he wrote me back, you have not seen all, because the case I referred to was from the 50s, and he submitted then a case from the beginning of the century, because it was the leading case for the category. So that the age is not really important. We want the leading cases. If they are old, we're fine with that.
And what about the practical distribution of the how do you assume how many books are in Finland, in Baltic states?
No idea. The commercial aspect is unknown for me. What do we have done, at least for the first volume? For the second one, I'm not sure. The first volume had been put online. But I think it's paying. And probably it is online on the site of the European Centre of Tort and Insurance. But I would have to check it. It had been. I'm not sure whether it is still the case. But this would be an easy way to have access to it. Besides that, what I can say with certainty that is that each author of a country report has, of course, a new home.
Well, I also have a question. First of all, let me thank you for this very interesting presentation. It was interesting for me as well, although I have read both of those volumes, and I have been an author of the third. And the question is regarding the interaction between fault and unlawfulness. And I have an impression that in most European countries, the end result, as you already mentioned, is more or less the same. Nevertheless, the concepts are quite different. I know that in the Netherlands, it differs a bit due to a more subjective approach towards fault. In contrast, for example, in most jurisdictions, I think it's purely objective. And I think, well, what do you think? I think that the end result is more or less the same, and the differences are merely theoretical rather than having any practical, let's say, influence on the end result.
What I explained to you, I would not explain to everybody, but because certain colleagues would kill me. Especially in particular in France. But I consider that unlawfulness is a logical category as well as conditio sine qua non is a logical category. Because at the moment where you speak about the norm, you cannot avoid the question, has the norm been respected or has the norm been violated? You cannot have a norm without asking this question. Otherwise, the norm is just a theoretical cloud somewhere in the sky. And this is exactly unlawfulness. If you say the norm has been respected, you would say it is lawful. If you say the norm has not been respected, then you would say it is unlawful. This is unlawfulness. So, even if French law does not speak about unlawfulness, they necessarily need this category. And as in Portugal, for example, they do not think in terms of, or they do not mention the term conditio sine qua non. The French judge does not mention the term unlawfulness because it's not in the law. But when he applies law, he cannot do anything else than to use this criteria of break of law. This has as a consequence that the outcome, whether you distinguish or not unlawfulness and fault, the practical outcome is very similar. Then the important distinction, difference is in the form of fault. How high is your level of fault? This is the real difference. And what would you consider as a fault? When would you say X behaved in a diligent way, and what are the conditions for saying X behaved in a negligent way? There is the difference. So the real impact will be on the level of fault. But we need, theoretically, we need both unlawfulness and fault.
Okay, but first I think the question is regarding how we measure the unlawfulness, or do we measure unlawfulness by the result or by the affection or link with certain norms or the legal framework existing in a particular jurisdiction? And well, I think if the former approach is applied, then it would be easy to conclude that in every case when damage is inflicted upon another, the person has acted wrongfully, and therefore further justifications, and for example whether or not the person has legal capacity to be liable for a tortious act or omission is at stake.
Yeah, there is, in fact, there is a difficult question about unlawfulness of behavior and unlawfulness of result. This is a German distinction. No, I must say, everybody thinks that this is a German distinction. In fact, it is a Roman distinction. The Romans used this, and the Germans saw that and used it also. I think that the distinction is not as important as that. If you speak about unlawfulness of behavior, you focus on the behavior of the person. If you speak about unlawfulness of result, you focus on the damage. For example, if someone cuts my arm, I can say unlawfulness of result because my arm is cut. If someone does not respect, let's say, traffic light, then someone would say it is unlawfulness of behavior, but because his behavior was such that he did not respect the traffic light. Now, for tort law, the Romans have an extremely good concept of that, saying that in fact you need generally both. You need a behavior of someone, behavior or omission of someone. Without behavior or omission of someone, he would not be liable, of course. So you need a behavior or an omission, an act or an omission, in the one hand. On the other hand, you need a result. If you don't have a result, if you don't have damage, so no damages. What means that in fact, the strict opposition between unlawfulness of behavior and unlawfulness of result is artificial, because you always need both. Except that in certain cases you focus on the one because it's more important, or you focus on the other because it's more important. But no damages without damage, and no damages without behavior. So those who say we don't want to have any more unlawfulness of result because there is necessary a behavior leading to a damage, those, in my sense, have not understood really what are the requirements for tort law. Yeah. Here again, some of my colleagues will kill me.
Thank you. Just a brief comment. It is exactly how I see it, and probably a new idea how to interpret this notion of unlawfulness regarding Latvian law is basically to combine both, that it has to consider an act or an omission lawful, it has to infringe another person's rights, and it has to be it has to derogate from the necessary standard of care established either by written law or unwritten practice or some other evidence. But yeah, thank you very much for your answer.
Thank you very much. And see you tomorrow in another place.
Okay, it was a pleasure.